So we have this decision by the Supreme Court several years ago. It's really a bastardization of the law called Massachusetts versus EPA, 5-4 decision. John Paul Stevens writes it. And, of course, the older he got, the more whacked out he got. Empowering the EPA to do something the Clean Air Act does not empower the EPA to do, and that is to regulate non-polluting substances, including carbon dioxide, and theoretically including water vapor. The problem is, ladies and gentlemen, the statute itself provides a threshold. A threshold. So if a pollutant meets the threshold, then the EPA can regulate it. In fact, if it's a pollutant, it must regulate it. But the Supreme Court said when it comes to greenhouse gases, it may regulate it. Well, the problem is if they start regulating carbon dioxide before they even get to water vapor or the rest, which really they can't even figure out how to regulate, there's too much. As Justice Scalia wrote in his dissent footnote number 2 in that Massachusetts versus EPA decision of 2007, he said it follows that everything airborne from frisbees to flatulence qualifies as an air pollutant. So now that the EPA got its way in a 5-4 decision that it may regulate anything and everything in the air, even non-pollutants. Well, now they want to regulate carbon dioxide in the worst possible way. But they don't have any conceivable way of regulating everything. That is, how you breathe and take it from there. I mean, virtually everything creates or consumes some aspect of greenhouse gases, right? So they got an idea over there at the EPA, under the Obama administration. Let's change the Clean Air Act by regulation. Let's change the 1970 Clean Air Act by regulation. We'll change the threshold. It's just too big. I know this seems counterintuitive, but they can't get their hands around it, and they don't want to tick off everybody. We got to figure out, we really want to go after these big businesses, the real polluters who create greenhouse gases, carbon dioxide. So we'll change the threshold. We'll just change it. And so they changed it. Well, there's a problem with that. It's called separation of powers. They're not allowed to rewrite statutes. I know this is a shock in modern-day Obamaville, but they're not allowed to do that. Only Congress can write statutes. And the EPA cannot, by regulation, alter the specific language and thresholds in a statute. If Congress wishes to do it, then Congress can do it. And so Justice Scalia said no. And he was joined by 4 others: Alito, Thomas, Kennedy, and Roberts. He said, we conclude the EPA's rewriting of the statute thresholds was impermissible and therefore could not validate the agency's interpretation of the triggering provisions. An agency has no power to tailor legislation to bureaucratic policy goals by rewriting unambiguous statutory terms. Do you realize that only got 5 votes? 4 justices, for the most part, voted the other way. 4 justices, in essence, voted against separation of powers. 4 justices, in essence, voted in favor of bureaucrats substituting their will for members of Congress. I mean, if Congress wants to change this, there's a process for that. The executive branch is not a lawmaking body that can make laws via regulation, rule, or fiat that usurps Congress's power. Now, what's amazing about this, folks, is this is one of the few times any federal court has pulled back on the excessive lawmaking powers of the executive branch. I mean, I've made the point in the Liberty Amendments that we have this non-delegation notion that Congress cannot delegate lawmaking powers to other entities, or it is a complete ruination of the notion of the consent of the governed. It's a complete rewrite of Article 1. But since the New Deal, when FDR tried to pack the court, obviously that has changed a lot, or we wouldn't have had a New Deal. And the courts have almost gone along every single time. I'd say 98% of the cases get thrown out or the government's position is upheld. So in that sense, it's very rare, a 5-4 decision. Now, that said, EPA still has enormous regulatory powers beyond this, or apart from this. And that also said, there were 2 justices who got it even more correctly than Antonin Scalia, in my humble opinion: Sam Alito and Clarence Thomas. Because by a 7-2 vote, those men said, we really should revisit the Massachusetts versus EPA decision, because that was incorrectly decided. But it was only the two of them who voted for that. 7-2. Those men, Alito and Thomas, were absolutely correct. But it's apparent that they couldn't get 5 votes to do that anyway. The point is, folks, we have 4 justices on the Supreme Court who reject this notion of separation of powers, who believe in a massive authoritarian executive branch, who do not see distinct lines of separation of powers. At times they can be ambiguous, but they certainly weren't ambiguous here. And I'm telling you all this so you understand the decision, because none of the reporting has been very helpful. And, of course, I and Landmark Legal Foundation were involved in this decision. We were asked to file an amicus brief, a friend of the court brief, as we did, and several of our arguments, among others, were embraced by the majority. This is why I don't give that up, because it's very, very important in my view to not only talk about these things, but to do something about them. And I know the other hosts wax on and on and on about, look, I'm just a radio host. Well, I'm not just a radio host. Although I love it, and I'm blessed to do it, and it's the 3rd biggest program in America, and anybody who says differently is lying, but it's true. Today, as far as it went, could have been better, but the EPA has enormous power outside of this decision. And, if Congress doesn't want to act, the executive branch shouldn't be acting in its stead. The executive branch shouldn't be acting at all. I don't care if Obama has a pen. We have a Constitution. Now, I believe, I hope, you have a better understanding of what happened today with the Supreme Court. And usually when these cases come out, I get about 400 emails. People want me to customize some response to them. Mark, what happened today, please? And I said, just listen to the show. I can't write everybody and do a critique for everybody. Just listen to the show. That's the whole point of the program. And, see, the problem has become this, with the presidency and the executive branch generally, and not just them, but Congress and even the courts. Any idea or desire or thought somehow can now be mandated. I mean, Obama's going on and on today about what he thinks the workforce should look like, and I thought to myself, why does that matter what he thinks? If he wants to start a business and he wants to do those things, then it matters, but he's the president. Every thought that comes through his mind that, well, the French do this, and, and this one does that, and this one does, who cares? Who cares? He's part of the government. The government has no say in this stuff. Certainly shouldn't. I mean, he creates this notion of this beautiful workplace where, you have family leave and this happens and that happens. The problem is not enough people are in the workplace because of his policies. They not only have family leave, they have endless leave. Leave from a paycheck, losing their mortgages, and they're relieved of their bank accounts and so forth and so on. So absurd to have a president who is overseeing the worst post-recession economy in modern history, whose policies have specifically resulted in this, lecturing everybody about how they should run a business. Man who couldn't even get a website up.